What am I going to cover? Firstly, what do we mean by a data protection impact assessment? Who should instigate or carry out a DPIA? How and when to use a DPIA? The process for it, and then the latest guidance from the Information Commissioner's Office in the UK and other EU regulators on DPIAs. There is within GDPR, let's not forget, an obligation where the DPIA reveals high-risk issues that if there's a mandatory data protection officer, they should consult with the relevant data protection authority in order to get clearance from the regulator before proceeding further. Where you have, or indeed where you are, the DPO, you need to be aware that this is your right and your duty. And therefore, you need to be clear within the business about how you are involved as a DPO in the DPIA process. And if at the end of all of the questions you conclude no DPI is necessary, then log that, record that. Remember that the DPIA, unless the impact is high risk, doesn't have to be discussed with the regulator. It's something that can be filed, but can be brought out in anger if you need to robustly defend why you went ahead with a particular project. The regulator, for example, might not necessarily agree with your conclusion, but the fact that you went through the initial process is going to put you in a much better light than if you'd simply avoided addressing the issue at all. So almost this is as important a part of the process as anything else.